If you're a buyer who walks away from a real estate deal, your deposit is likely gone. It doesn't matter why you walked away, and it doesn't matter if the seller suffered any actual damages. Now, I was a licensed realtor and am now a real estate lawyer. I've sat on both sides of deals, and deposit forfeiture is one of the most misunderstood rules in the industry. So if you're a buyer, a seller, or a realtor in Ontario, stick around, because understanding how deposit forfeiture works could save you thousands of dollars if you ever find yourself on either side of a deal gone wrong. My name is Zachary Soccio-Marandola. I'm a real estate lawyer here in Toronto. If you enjoy this content, make sure you subscribe and join our community. And if you have a closing coming up, we've built the most transparent legal calculator online. Gives you a full breakdown and even calculates closing costs like land transfer tax and title insurance. That's linked in the description below. So let's start at the beginning. What is a deposit in the eyes of the law? So a deposit is money that the buyer puts forward as a good faith guarantee that they intend to close the deal. It says, I'm serious about this transaction and I'm putting real money on the table to prove it. Now, if the deal closes as agreed, the deposit gets credited towards the purchase price on closing. The buyer doesn't lose it, it gets applied to what they owe. That's the normal outcome. But if the deal doesn't close because the buyer defaulted, that means they walked away, they couldn't get financing, or they changed their mind for whatever reason, the seller is entitled to keep that deposit. Now, here's something a lot of buyers don't realize. The right to forfeit the deposit doesn't need to be spelled out in the contract. In Ontario, forfeiture arises from common law. That's previous case law. It's the default rule. Even if the agreement of purchase and sale doesn't say a word about what happens to the deposit if the buyer walks, the seller can still be entitled to keep it. So if you're a buyer thinking that the contract doesn't specifically say you lose it, that doesn't matter. The common law fills that gap. Now, this leads into the part that surprises people the most. The seller keeps the deposit regardless of whether they've suffered any actual damages. So to say that again, even if the seller suffers zero financial loss from the deal falling apart, that deposit is forfeited. And it goes further than that. Even if the seller turns around and relists the property, sells it to someone else for more money than you agreed to pay, they still keep your deposit. So think about what that means in a real estate transaction. Let's say you agreed to buy a home for $900,000. You put a $50,000 deposit down, then you walk away. The seller relists, and a month later they sell it for $950,000. They made more money than they would have on your deal. They still keep the $50,000 from you. You gave the seller that money as a guarantee that you would perform, and you didn't perform. Now here's the other side of this. That deposit is the floor, it's not the ceiling. The seller suffers real provable losses. Above and beyond that deposit amount, they can still pursue the buyer for those additional damages. Keeping the deposit doesn't close the door on a further claim. So what kind of losses are we talking about? Could be the difference between what the buyer agreed to pay and what the property ultimately sold for to a new buyer. It can include carrying costs, that's mortgage interest, property taxes, utilities, condo fees, things that the seller kept paying while the property went back on the market. Could also include additional legal fees, can include additional real estate commissions from having to relist. In a falling market, those numbers can get very large very quickly. There was just a recent decision in an Ontario court where they ordered a buyer to pay $1.8 million in damages after failing to complete an $8.3 million property purchase in Mississauga. Now, that right to pursue additional damages, it does come with some obligations attached. So when a buyer defaults, the seller can't just simply sit there and do nothing and let those losses pile up. Ontario law requires the seller to take reasonable steps to minimize their losses if they're going to claim for damages. This is called the duty to mitigate. In practice, that means relisting the property and making a genuine effort to sell it within a reasonable time. But that doesn't mean the seller has to take the first offer, and they don't have to accept a lowball just to close the file. But they do have to be actively trying and acting reasonably. Now, there's one more concept that buyers and sellers alike should know about. It's called relief from forfeiture. So a defaulting buyer can apply to the court to get their deposit back. Courts have the power to step in and relieve a buyer from forfeiting their deposit where they consider it just to do so. But that test is very high. There are two things that need to be true. First, the deposit has to be completely out of proportion to the damages that the seller actually suffered. Second, it has to be unconscionable, meaning so grossly unfair for the seller to keep it that the court is prepared to intervene. And in practice, courts have been very clear. This is an exceptional remedy. The fact that the seller suffered no damages is not enough on its own to grant relief. Courts look at the full picture. So that means the sophistication of both parties, whether there were any negotiations that took place, whether the buyer took on specific risks like waiving a financing condition and then failed to close. So for a typical residential buyer in Ontario, putting anywhere from 5 to 20% down as a deposit, courts have consistently upheld full forfeiture, even with no evidence of any damages suffered by the seller. So relief Often forfeiture does exist, but don't count on it. If you walk away from a deal, the assumption is that that deposit is gone, unless we're talking about very extreme circumstances. Alright, so that's the summary on deposit forfeiture in Ontario. What a deposit actually is, why you lose it if you default, regardless of whether the seller suffered any actual losses, why the seller can still come after the buyer for more money if damages go beyond it, and the narrow circumstances when a court might step in. So if you're ever facing a real estate deal that's at risk of falling apart, whether you're the buyer or the seller, get a real estate lawyer involved early. The rules here are well settled, but the situations never are. If you're enjoying these behind the scenes real estate law videos, make sure you subscribe to the channel. I post a new video every week. And if you're a realtor, I also send a weekly update about different legal situations that come up in our closing. That's our realtor newsletter, and you could subscribe to it with the link down in the description. Thanks for watching.